Any mention? Supplementary list, item number 1.
Please, Your Lordships. Yeah. Also, by way of this writ petition, I'm assailing a judgment dated 31/7/24, passed by the learned single judge in a writ petition, because there's been a delay of about 16 days in preferring this appeal. In addition, the appellant before Lordships was not a party to the original case before the trial, before the learned single judge. As such, I filed an application seeking leave to prefer this appeal. And notice would have to go on both these applications.
Yes, Mr. Karuno, you're busy with your phone.
Lordship, my apologies, Lordship. I just got
very bad manners, I'll tell you.
my apologies, Lordship. Lordship, I just
You're a
got
decent
informed
chap,
by
and then you should
Lordship,
be
the
attended
Connect
to the
Council,
court.
Mr. KP, who's
Yes.
conducting this case, Lordship.
Doesn't matter. Yes,
My apologies, Lordship. Lordship, I'll.
in this case, you accepting notice?
State we've already served, my lord.
Okay.
There are two private respondents, 7 and 8.
right. 7 and 8.
7 and 8.
Yes, heard Mr. The Senator Counsel for the applicant. This case 41. This is issue notice. Mr. H. Karan Langs accept notice on behalf of respondent number
126.
126. Notice issue to the remain response within 3 days. Stop. Just after when 2 weeks. 2 weeks for consideration. Yes.
Are you obliged?
What about the others on coordination or is it this? Yeah.
On both,
41.
I'll issue notice. Obliged.
Daily list, item number 1.
The state has filed an affidavit.
Regarding where's the petition in person? Where's the affidavit? The dogs or this 19/6. Which affidavit?
Sorry, apology, Lordship.
Wait, what affidavit? Last affidavit was filed on 19th of June. Yes.
Lordship, this is the Shillong Dowki.
What affidavit you said you filed?
No, Lordship. I thought the latest affidavit, Lordship. Sorry, apology, Lordship. This was a different case.
Yes.
So the affidavit basically is for the Highway Authority to.
What is this? What is this?
This was
document
regarding,
here?
Lordship, the court is monitoring. The PIL was filed regarding felling of trees in the Shillong Dowki. Angeli petrol pump to Dowki, Lordship. So there was felling of trees issue involved. And state was supposed to assist the National Highway Authority in at least handing over the land whenever it was required. So the court is monitoring as to the stage in which the progress has been made.
What is the status of work? What is this?
Status of work, Your Lordship, it's for the highway authorities, NHI, DCL. So there has been four phases where the work has been started. So far,
The matter appeared last on 20th of June.
Lordship, yes.
My lord.
Now, what status report that have been filed on 13th October and without the permission of the court?
Lordship, the status report.
Oh, sorry, the 23.
23.
I thought
Sorry,
24.
Lordship, the report was regarding progress. What is the state doing so far? The handing over the land matter is concerned. And the progress report in terms of what has happened to phase 1, phase 2, phase 3, phase 4 is for the highway authorities, Your Lordship. And court was monitoring as to the nature of progress being made.
Yes, Dr. Mozika,
My lord, the last affidavit we filed was in the month of March, my lord.
March of this year.
March of this year, my lord.
What do you say in the affidavit? That's the affidavit.
In fact, we filed in June also, mailed one affidavit. The affidavit of 19th June, my lordship, and
Yes. My last affidavit.
filed on 19th of June.
Mm.
But here we have stated, my lord,
It was filed by the state,
Mahavir Singh Rawat, my lord, NHITC,
19th of June.
19th of June.
Okay. Yes.
But here we have stated, my lord, because the entire stretch is divided into 5 packages, my lord.
Yes.
Now, in respect to package 1, we have stated, my lord, para 6 and 7, lordship kindly says.
One belong to Million. Then some package 2. Yes.
So this is to
package,
be completed,
5 and 6.
para 5 and 6, my lord.
Para 5 and 6. Continuous flow of all of action.
So, my lord, the earlier contractors abandoned the work, my lord, because there was no clearance of land. So, we have retendered it, and work was awarded to the new contractor on 23rd of October 23, and the completion period is 2 years, my lord. And as on the date of filing affidavit, the contractor achieved 17.5% physical progress,
process.
my lord. In respect of package 2, my lord, the previous work was terminated and balance work has been re-awarded to the EPC contractor, Mrs. YFC Project Private Limited, with a project completion time of 2.5 years. Appointed date has been declared as 9th of February 24. Accordingly, work is in progress. 100% encumbrance-free land has been handed over to the contractor. As on date, EPC contractor achieved 4.7% physical progress of the work, and the financial progress of the work is 0%. Package 3, my lord, that the alignment of Peninsula Bypass, Shillong Dauki Package 3 has been approved by the state government and headquarter NHITC. Accordingly, the DPR preparation work is in progress. Further, joint inspection was fixed on 14th May to 17th May by Revenue East Kashmir District for carrying out the detailed survey along with alignment finalized by the state government. However, the same could not be done due to strong objection raised by the locals. The matter is required to be resolved by the state government. Package 4, my lord. As regards Dauki Shillong Package 4, the previous work was foreclosed due to non-handing over of Mausoon bypass stretch by state government, and balance work has been re-awarded to the EPC contractor, Mrs. So-and-so. Further, contract agreement has been signed on 7th March 24, and the appointed date has been declared as the 19th of April 24. About 95.3% encumbrance free land has been handed over to the contractor. Further, the remaining stretch of Mausoon bypass, 710 meters, held up in 25 numbers of pockets, and 173 meters apart from the above, 6 numbers of pockets are yet to be handed over by the state government. As such, the total affected length is 883 meters. As on date, the EPC contractor achieved 0.4% physical progress. Package 5, my lord, that as regards Long Dauki Package 5, the previous work was foreclosed and the balance work has been re-awarded to the EPC contractor, Mrs. ASC Infratech Private Limited. Contract agreement has been signed on 7/3/24, and the appointed date has been declared as 17th May 24. About 98.7% encumbrance free land has been handed over to the EPC contractor on appointed date. As on date, the EPC contractor, the physical progress of the work is 0%. Because this affidavit was filed in the month of June.
Anyway, and then why did Mr. Khan said about cutting trees? Where's the cutting trees part? Regarding cutting trees.
Initially,
started off with
initially
cutting
the
of
PIL was
trees.
filed. When the heritage trees were sought to be cut, my lord, along the
Was
airport.
it a very old PIL, that means?
This old
Yes.
PIL. This is 22, my lord. Then the later on the scope was widened, my lord.
You do one thing, Dr. Mozika, you just give, you will post it after 4 weeks.
My lord.
Then just give a status report. Maybe it can be closed also after that. If the project is going on.
My lord, what has happened, my lord, you also seen still till date, my lord, in certain stretches there are.
Still, so we need court orders.
My lord,
That one that is still encumbered, you mean that part?
two
That
stretches
has to be clarified. That's our state
Peninsula
government.
stretch has not been resolved till now. my
Take
lord.
down. This matter has been tested after a considerable period of time. Stop. And the last status report on affidavit is dated 19/6/2024. Stop. Next, Learned Senior Counsel Dr. N. Mozika has read out the relevant aspects of the affidavit and has also submitted that certain sections, some encumbrances still remain with regard to the handing over of land.
And especially Peninsula stretch. my lord.
In Peninsula stretch.
The land is in two more stretches. Peninsula is not resolved at all, my lord.
Okay, yes, Peninsula stretch and others. And okay, in two stretches. Peninsula being one stop. Next paragraph. In his view, the matter that a fresh status report be filed within 4 weeks from today. It is expected that the state government also will apprise the court through affidavit as to the encumbrances which have been flagged by the counsel for the NHIPCL. Just accordingly on so.
Dip.
Item number 2.
But I've just been served with a copy of the counter. I'll require some time to file my rejoinder, my lord.
Challenging the virus of the act.
Yes, the amendment, my lord. The proportion of promotion has been reduced from 35%,
From?
from 35% to 25%, my lord. And there's certain other.
You're okay. Yes, no, sorry, Mr. Philemon Nongri. Counsel the petitioner submits that appraisal is allowed how much time?
2 weeks, my lord.
2 weeks time to file the jointer to the affidavit filed by the state respondents. This is allowed is after 2 weeks.
Deeply.
Item number 4.
It's regarding the suing.
But in terms of your lordship's last order, my lord, the municipal were required to file a report.
Report
my,
ready?
My report is ready, my lord. I'll file it by tomorrow, my lord.
What about your instructions on the affidavit filed with the respondent?
I'm making a similar prayer, man, insofar as the affidavit filed by the state is concerned, man.
Tomorrow. Yes, Mr. Philemon Nongri, counsel respondent submits that the report is ready and submits that report is ready in the course of filing it,
By tomorrow, my lord.
and the same will be filed on affidavit by tomorrow. From the Estapa, as present on behalf of the petitioner, lists this matter after 2 weeks before the order is written.
Deeply.
Obliged.
Hearing. Item number 3.
Please. JW.
Lordship, the matter pertains to pay parity in Assam Rifles. Before taking your Lordship to the judgment under appeal, the brief history goes like this, my Lord, that in the year 2010, around 1,339 persons in the clerical trade of Assam Rifles, they come before this court and they institute a writ petition saying that their rank and pay should be made equivalent to other paramilitary forces by introduction of a rank of warrant officer in their service. So that writ petition, my lord, it gets decided in the year 2012. In my appeal, lordship would find that in page number 338, my lord, is the conclusion,
Section 11, section 12 appellants here.
my lord,
Section 12 appellants here.
my lord.
Yes, 338.
338, my lord. 338 is the effective direction that comes in the judgment.
338, okay.
The language herein is, my lord, vital to read. Lordship has got para 14. That in the result, this writ petition stands disposed of with a direction to the respondent number 2, the Director General of Assam Rifles, to take up the matter again with respondent number 1, that is the Secretary to the Government of India Ministry of Home Affairs, to bring parity in respect of rank, structure and pay of Assam Rifles clerical trade at par with other CPOs by introducing rank of Assistant Sub-Inspector within bracket warrant officer at the entry grade with effect from 1/1/1986 in the scale of pay of so and so. What I would like to emphasize in this line, my lord, is that the order, my lord, it says that bring parity for the clerical trade. The word here is, my lord, not the petitioners only. So the entire trade, though everybody from the trade was not before the court, the language of the judgment, my lord, it says that the entire clerical trade should be considered. This was taken in appeal, my lord. In the next page, lordship would find that rate appeal 40 of 2012.
Yes.
That also gets decided, my lord, at page 372, my lord, in favor of the petitioners. The only modification that was done in the writ appeal is that this date of 1/1/1986, my lord, it was changed and it was sought to be made from the date of the judgment onwards.
Yes.
But then when the matter in the next page, my lord, traveled to the apex court at page 373, rather than upholding the division bench's order, the learned single judge's order was upheld. So therefore the date goes back to 1/1/1986. Then in the next page, my lord, at page 375, comes the implementation order. The ministry and Assam Rifles, after due consultation, they say that in compliance of judgment dated 23/8/2012, passed by the Honorable Guwahati High Court, Shillong Bench in WBC 277, Radhakishan, and so, I am directed to convey sanction of the competent authority to bring parity in respect of rank, structure, and pay of Assam Rifles clerical trade at par with other CPOs by introducing rank of Assistant Sub-Inspector Warrant Officer at the entry grade with effect from 1/1/86 in the pay scale of so and so. But then the last line also I would read, continues like that, that it would be for those who are enrolled thereafter up to 28/10/2002. This 28/10/2002, my lord, it comes because on 28/2/2002, there was an amendment to the recruitment rule. Not, in fact, an amendment. Recruitment rule, my lord, had come where earlier the clerks were called Lance Naik writers. Instead of that, in 2002, they were started to be called Havaldar clerks. So that was the only change in the recruitment rule. Now, it is an accepted fact otherwise that the pay parity between Assam Rifles and other paramilitary forces was considered and it was made equivalent. So our case now is, my lord, the persons who were left out and who did not join in that earlier round of litigation, they remained Havaldars, whereas the persons who had joined, for them the entry gate has become warrant officer, and the persons who had joined after 2002, my lord, they come into an entry grade of Havaldar, my lord. The issue, therefore, that we raise as core issue in this petition is that...
What trade? This, your appellants?
My lord?
They are which trade? Which trade are they?
They are clerks, my lord. They are clerks. So in the clerical trade, my lord, there are two entry gates, therefore. One, they are doing, they have the same qualification, they do the same work, But then people before 2002, their entry gate had become warrant officer with a higher rank and pay, and people coming subsequent to them, my lord, they were, my lord, given a lesser rank and pay.
Yes.
Now, in this implementation also, my lord, there was a catch. They said that out of this 1,339 people, there were 89 persons who had joined after 2002 recruitment rules, and therefore, we will not grant them the benefit. My lord, then there was a contempt, and in the contempt, my lord, the implementation was done again in respect of these 89 persons also. That implementation, my lord, would be at page 387.
Can I take up this matter now?
My lord,
And the contempt, see. You see page 381. Right page.
yes, my lord, I can see now.
If you,
I had escaped my notice earlier, my lord.
It's same, it has escaped. I haven't looked at the file. If you're seeking to place reliance on this, then maybe
It had escaped my notice also, my lord, page 386.
Yes. 81, 381 also.
Yes.
381. So we'll close it here.
But then, my lord, we are not these petitioners. We are, my lord, though we are relying on this, my lord.
That is why.
We are not relying exactly on this also, my lord. If I am permitted to continue, that our cause of action is slightly different. This also got implemented. And not only this, my lord, thereafter, my lord, in additional affidavit that we had filed, we had shown that another group of, my lord, 192 persons also approached in 2019 through WPC 198 of 2019. Their prayers also were also allowed, my lord. They were also persons who had joined after 2002. Their prayer was also allowed. The SLP in respect of the same also gets dismissed and the order is implemented. But in our case, my lord, what was considered by the learned single judge, my lord, if...
now, only thing is that
we were called, my lord...
Have you said that a woman's been additional affidavit in the Supreme Court judgment, correct? In SLP number 1521 will not cover the case. That's your only objection.
Yes, yes.
Yes.
So you see, my question is here, that's why it is not covered.
Why not covered?
Because you see, first round of litigation, 89 people, they are not entitled for the benefit, but it is
How many?
89 people,
Okay, 89.
they are not even entitled, but when the affidavit is filed, it is not brought to the notice of the court. Secondly, you see, when division bench, this division bench is considered, then also it was not brought to the notice of the court. Even in the Supreme Court, it was not brought to the notice. So finally, judgment will come from the Supreme Court. At the time of implementation, then it is found that 89 persons, they are not entitled, but in the judgment, according to the judgment, they have to give. So ultimately, it has been implemented. So when it is implemented, your lordship, then questions come up, what's about others? Then this writ petition has come up along with others. So other writ petition now in Supreme Court, when it is dismissed, it is only for the purpose of delay, because there was delay. There is another question was there received in the first this single bench, when the pass the judgment, it is not challenging the division bench, stated to the Supreme Court, there was delay. But even considering these matters, this Ajay Kumar and others, this given in the additional affidavit, why it is not applicable in their case? Because you lordship, Ajay Kumar and others, this they have filed a petition because junior to them become the senior due to implementation of this first judgment. So court has considered that in such situation, could feel that it will be appropriate to give them the benefit because their junior become the senior. So Ajay Kumar that is considered, and then now it is going to be implemented because it is come. But here in this case, this analogy will not come. because they are not affected. And if you go as per this recruitment rule, then 89 also was not in a position to get the benefit. Even now this 192 is coming, they are also not supposed to get the benefit as per recruitment rule.
No, that's
So
what I-
now whatsoever mistake committed, it is even admitted in our affidavit that this is the mistake committed. So this mistake should be perpetuated. This is the question in this case here. We cannot deny this matter that first litigation, 89 people were there. It was our responsibility to check up whether they will be entitled for benefit or not. But we didn't see. And this was mistake. This is admitted position, Your Lordship. I cannot say that there is some other thing.
My Lord, the
And that person who got the benefit, being a junior, up to this line, the benefit who are entitled, all of are given now.
the question, my Lord, is that
So petitioner question is there, yes, because other is given the benefit of this higher rank and other, then we should give it.
Yes. Yes, Mr. Pathak,
My Lord,
what's wrong with the
the
single
mis-
judgment?
Here you
the
will say,
mistake, my Lord, is basically they say it's a mistake, but then the mistake is a way now they are devising to overcome the verdicts of the
mistake they
court.
made.
I am not saying do perpetuate a mistake. I am saying
I
that
think very few mistake. Their mistake that they.
no, there is no mistake, my Lord, because
Why?
the wrong they are committing, my Lord, is that they are saying that warrant officer we have introduced, but then it is not applicable to you. But then this entire concept, the Lordship had dealt with a number of litigations. The warrant officer concept came from the Fifth Pay Commission, that this is a rank to be introduced with this pay. Now, this warrant officer is not a post which is a promotional post. It is neither a post that finds mention in the recruitment rule till now. So it is essentially a ex-cadre post. That post, I will not call it a post, that rank and that pay was introduced in Assam Rifles just to bring parity and to implement the Fifth Pay Commission. Had that been a post, my Lord, which is finding a place in the recruitment rule as a promotional post, then of course there is a distinction between Havaldars and warrant officers. My Lord, here is a case where both come in as an entry gate clerk and somebody gets a higher rank and pay and somebody gets a lesser rank and pay, doing the same work, my Lord. It's no longer a question now of, my Lord, our being compared to other CPOs. But within the Assam Rifles clerical trade itself, there are two categories now, one with lesser pay, one with higher pay and doing the same work. Therefore, we are seeking parity within the Assam Rifles.
Let's see the single judge's order.
My Lord.
you will see here in this aspect, the matter, may I just, you will see this petitioner, they have recruited on the basis of the recruitment in 2002. So prior to this, Fifth Pay Commission or the whatsoever thereof, they should not have even right to even argue on these matters because they are not entitled any benefit in 1986 and other were benefit given Fourth Pay Commission, Fifth Pay Commission.
Let's see the single judge's order. What is the
My Lord,
their
page
their
440.
situation in the service when they join?
My Lord. Page 440, my Lord. What they are missing is that, my Lord, that this warrant officer was not existent even before 2002. They were Lansnaik writers. That Lansnaik writer, my Lord, got renamed, only renamed in the 2002 recruitment rules as Havaldars. So there's no distinction between the persons who were recruited before and recruited after. Only a difference of name. And the persons who were recruited before 2002 also, there was no recruitment rule saying that you couldn't be made warrant officer or your entry gate would be warrant officer. It is purely an ex-cadre post, my Lord. So it says, my Lord, should I read, my Lord? Or?
No, midwest part is finding.
The essential consideration was that we are fence sitters, my Lord, that we did not join the earlier round of litigation. Reliance was placed on this decision of 452, my Lord, of R. Muthukumar and others.
Where is that? Which paragraph?
My lord, if Lordship comes to para 27, this is where we beg to differ also, my lord. It would be page 451.
The judgment dated 23/8/12.
No, my lord, I'm reading the judgment that is
But single
under challenge before this division bench.
27.
Para 27, my lord. At
It
page
starts with judgment
451.
dated 23/8.
No, the judgment dated 23/8/2012 is a judgment in personam, as could be evident from the proceedings in contempt case so and so. This finding, my lord, that it is a judgment in personam is basically what we disagree. And that is why I pointed out while reading para 14 of that particular judgment, it says the clerical trait should be now considered for giving the rank of warrant
So only
officer.
the consideration that they were not before the court at the relevant point of time, they were, I mean, the other consideration that Mr. they're not saying were not considered at all, the other submissions with regard to the, right?
The recruitment rule, my lord, though it is mentioned, there's no finding written in respect of that, my lord. The primary reason is that basically it is not in personam. It's a judgment in personam, therefore we will not be guided by that. And since you are delayed, you did not join in 2012, you came in 2019, you cannot as fancitors be riding on the litigation of somebody else.
451 page, para 25, it is clearly mentioned. This is just and even we taken in the single bench.
No, what he's saying, that means this case condemns the fact that only those people who are there in the entire litigation
My lord.
are entitled to relief. Because this 25, again, is what he says that through oversight and inadvertence, they've been allowed to participate in the proceedings of Registry 277. And then for this, the sponsor has to pay the price of said benefit of the said order dated 23/12.
The case they are making, I understand, is that because they framed the recruitment rule in 2002, in which says that the introductory, the entry level rank of Assam Rifles clerks will be Havaldar. They said that therefore you cannot be made warrant officers because that contains a pay and rank which is higher than Havaldar. So it would be essentially, they say that it would be tinkering with the recruitment rule. But then our contention is that that warrant officer is not a post in the clerical recruitment rules at all. And Lordship had found that in many other cases that it is not also a promotional post. It is a,
Is that a promotional
it is a rank that was introduced to bring in pay parity only.
Whatever it is.
And therefore, this 2002 recruitment rule is already diluted, my lord, by giving benefit to so many others. That even though in the recruitment rules the entry grade is Havaldar, people have been made to enjoy this rank of warrant officer with a higher pay and rank. And we are suffering because, my lord, we are also doing the same work. We come in with the same qualification. We sit as clerks. the persons who are having this rank of warrant officer, they are not seniors to us by having any promotion over us.
Mr. Pathak,
My lord.
I think because it has been extensive mention of the two contempt orders in the
Even
order
in
of
our,
litigants,
even
yes,
our impugned
and
order
also
also.
yes, in the impugned order, and view the fact that recourse has been taken to that to refuse your petitioners in their relief, although a tentative observations that there should not be any ground to deny you. So I think I'll have to recuse on this matter.
My lord, it is purely up to
I
your
hope
lordship.
it's understandable.
I understand. Even in the impugned order, this para 25.
No, in matter
Para
25,
25
27
also.
it's clearly mentioned that because of the orders passed, which had appeared as a senior counsel that time for the applicants. So only on that consideration,
My lord,
not on
I
the
understand.
merit
I
of the case
understand.
that on.
It is purely up to your lordship to recuse.
Yes, this is a matter for me, a bench out. Very sorry. All of these matters are, they are.
My lord, even it escaped my notice, my lord. I would have earlier pointed out.
Bridges.
Deeply aware.
Any mention?
Now, my lord, the matter which was fixed, 26, 27, but there's some bullet points. Yes. So bullet points are here. So we'll submit it and your lordship will close it, the entire matter.
What,
That matter.
My lord, 20.
no submissions, no more submissions.
No, no, your lordship said that.
Point only, my lord.
No, if your lordship wants to.
No, I'm saying if you've concluded,
Yeah,
the court perfectly
no,
authorized
that time I said, because of the three judgment which my learned friend has pointed out before this court, that has no relevancy in this case.
Right.
Because that is in the initial contract, giving to a particular bidder.
Mr. Das, if you want me additional submissions, we'll hear you. We'll hear you out here. You can submit it with no problem. Because if you have some clarifications to make, no problem.
Clarification, your lordship has given us a lot of time.
Yes, otherwise we can close it. We'll close it.
Your lordship
Let it be closed.
concluded the hearing
Yes,
and
we'll give it.
directed
We'll let the matter be called out that time. Then we'll close it. Yes.
Yes.
We'll stay back, my lord, when the matter is called for, or just.
Entirely up to you, Mr. Das.
No.
It'll be one line order. Okay. Item number.
26 and 27, my lord.
26 and 27.
Yes, 2027. Stop, Mr. Didas. Mr. President, on behalf of the petitioners and some critical points, he submits that he will not require to make any more additional submissions. Seems concurred to by Mr. Amit Kumar, Learned Advocate General. Matter stands. Hearing is concluded. Judgment reserved.
I am deeply obliged, my lord.
Right.
Good, sir.
Mention item number 20, Lucid. Item number 20.
What about it?
This is
What do you want? Upgrading?
No, you receive needs some
You
time.
just think item number 20. What does the court
So you receive to password this, sir.
to upgrading?
No, you receive. To fix another date.
You're just saying item number 20. I said yes, item number 20. No, you can't. This matter you've been adjourning it repeatedly.
No, you receive. I was not having the contract with this petition. I receive.
23 weeks. Okay. Yes.
But I'm, with the consent of Mr. Patak, there are two contents matter. We're praying for some accommodation today, my lord.
Those old ones.
My lord,
Because Mr. Paul is also.
Mr.
I
Paul
think,
is also not there. And the matter is, my lord, traveling again to the Supreme Court through another litigation, my lord. So I'm also awaiting, my lord, if hopefully something positive comes out, my lord.
Mr. Parak Court is tired of these two matters staring us in the face. 2015.
I understand, but then the complexity is such that because there are so many litigations on this issue,
Yeah, item number
16 and 17.
after.
But it be after Puja vacation, my lord. Then.
Yes, under the joint request from the parties. This is matter of the Puja vacation.
Deeply obliged.
But I'm also praying for accommodation for item 29, my lord. Today I have some personal level. I've done the research, my lord. That plea bargaining matter, my lord.
Pre-bargaining.
My lord. Well, I found out the judgments, but I have some personal difficulty. I have to leave today, my lord.
You're there.
Your
Item
Honor.
29.
No, Your Honor.
Who's there? PJ3.
No, I will just see first.
Monday.
Monday.
Monday you'll have Monday. You come up with, you do some research also.
Yes, sir.
Now when the section says court may
Me.
give imprisonment up to half the term, minimum term, correct?
Yes, sir.
May means may give up to half. Means that will it mean 1 day, or it means like may can give you up to half the term prescribed in the section 13(2) of the Prevention Corruption Act.
I have a direct judgment on that. I'll serve a copy to my friend. So you can go through it in the meantime.
There's a judgment from Gujarat also, I think, where taking into account the circumstances of the accused also.
Mitigating circumstances, yes, Your
Yes,
Lordship. Even I
and
have
so
gone through
that
that
is one
judgment,
thing.
Your Lordship. Depending on the age and.
The High Court division bench is clarified, my lord.
May mean 50%.
has to be read as shall in this book while interpreting this particular provision only.
No, but he says may also can mean even 1 day.
Your Lordship, if
The
the.
full may, it means that word
The
may,
Bombay High Court has said, my lord, may has to be read as shall and sentence cannot be reduced
less than 50%.
less than 50%.
You do some research, maybe find something other.
I'll give a copy.
Okay.
Is the contempt.
When?
Monday.
Monday, yes, list is matter on. That is, which item is it, sorry?
29.
29 is on Monday, on the prayer of the London THGI. We do some research.
Yes, Your Lordship.
Deeply.
Deeply obliged.
Lordship, I mentioned item number 25.
Yes, Dr. Agarwal.
Lordship, I pray that for some accommodation, if it could be listed after 1 week or 2 weeks as a Lordship.
Yes?
Maybe after 1 week or 2 weeks as your Lordship.
What's the matter about?
Lordship, the construction was not being permitted to the petitioner of the house on the property, and the Union of India is saying that the said property belongs to them, though they don't have any title document.
Okay, after Puja vacations.
Obliged,
Yes,
Lordship.
in the prayer of
Lordship, I beg to mention item 23.
Yes.
20,
Lord,
yes, she's submitting first, yes.
23, Your Lordship.
On
After
behalf
2
of,
weeks. Respondent number 5, Your Lordship.
here for the petitioner.
Yes, Lordship.
You have objection?
No objection, Lordship.
When? 2 weeks?
After 2 weeks, Your Lordship.
Okay, 2 weeks.
Deeply obliged.
Yes?
my lord, I'm appearing for item number 6 along with 7 contempt case. So the conducting counsel is out of station. So I would pray
Item number
the 6 and 7 contempt case number
6 and 7. You'll be held in contempt now. You know that this code doesn't allow mentions in part 1.
No,
You
your
add another contempt matter to your in your name.
no, my lord.
Then you wait for it to be called out. Yes.
Yes, my lord.
Don't mention part 1 matters. Court keeps on saying this. Mentioning hearing matters. Okay.
Lord, I'd beg to mention for one unlisted matter for tomorrow, my lord. This is that tariff matter, my lord, after the matter was...
After?
Tariff matter, my lord. Concerning
What tariff
tariff.
matter?
But after the petitioner, my lord, remanded back to the MECRC, my lord. My lord, our objections were filed, my lord, that was not considered. I don't know, they have again gone on to fix a date for final hearing, my lord, trying to undo the earlier tariff order which has already been passed.
The interim matters won't interfere, Mr. Thapa.
Well, I'm praying for tomorrow, my lord, may hear us, my lord, and thereafter, Lordship may pass.
We won't be too much interference. Tariff matters also is for one of dislocation, I think. Let it you record your objection. That is
My lord, all those orders were passed on the face or on the teeth of your Lordship's order passed earlier, my lord. In fact, those orders will not be sustainable in any case.
We can't interfere in the matter fixed for final hearings on Monday.
No, my lord, it's not on
When
Monday.
fix the final hearing. How we know will be taken consideration?
My lord, me hear it tomorrow. If it is on Monday, my lord, me hear it tomorrow, my lord. If it is on Monday, my lord, we'll take adequate instructions in.
No, sorry, this
in that
tariff
regard.
matters will be you file it. They'll come ordinary course on Monday.
I'm praying, my lord.
We
for tomorrow.
can't stop you from filing.
My lord, there's a bit of urgency in this matter, my lord. My lord, me hear it. If your Lordship opines that no interference is called for, my lord, me
Won't be pressed for time. Thing is, let it come Monday. It's not fixed on Monday, correct?
No.
Before the Regulatory Commission.
No, my lord.
Then
Public.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 18.
number 18.
I pray for 2 weeks' time, Your Lordship, as the contacting counsel is out of station.
Who's the conducting counsel?
S. Kumar, Your Lordship. He's on leave, Your Lordship. No objection, Your Lordship.
You're there also? No. 2 weeks, okay. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item 15 and 22. Your Lordship, the AAG is in bereavement.
Oh, yes. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item 24. 24 of the hearing list. Lordship, I'm praying after a week's time, 2 weeks' time, Your Lordship. No objection, Lordship.
That's a known fact, yes.
Highly
Your
object.
Lordship, I'd like to mention item 28, Your Lordship. 28, Your Lordship. 28.
Does that matter? Where's the PS Nombri?
Yes, Pompey is some personal difficulties, Your Lordship. That's why I'd like to mention.
Mr. Lindo, any objection? Any objection?
No, Your Lordship. 2 weeks, right?
2 weeks, Your Lordship.
2 weeks.
Yes.
2 weeks, okay, yes.
Objection.
Also the petitioner, yes.
May please, Your Lordship, I beg to mention item 21.
21.
Yes, Lordship.
All the matters are gone also.
Your Lordship, this matter, while the matter was fixed for hearing, the respondent had filed a second affidavit in opposition,
Second affidavit?
which is a reply to a rejoinder. We're still awaiting instruction. I'm pretty this matter may come out.
What second affidavit is filed?
Which is a
Captain, the
reply
price.
to a
What's the matter about?
rejoinder. They have filed without leave of this.
So department in the
Why you file without leave of this court?
It's a blacklisting matter. When the matter posted for hearing, recently they filed another fresh affidavit. It's called
How,
copy to us.
Dr.
Without leave
Monica,
of the
that's
court.
correct. Without leave of the court, they won't take into consideration. Withdraw the affidavit, then it's not with the leave of the court. How was it filed?
Well, on the file on 26/6/2024.
26/6?
Yes. That is when the matter already posted for hearing. They filed in the midst of hearing.
But I'll not refer to this one. I'll not refer to this. I just like to.
It is a matter today.
Well, next week, if the subject law should convince.
1 week, okay.
Yes.
We'll pass orders then.
Yes. Give the order.
Supplementary 1, item number 1.
My lord, in this case, we have challenged the order passed by District Council. Under the Act, my lord, the District Council is supposed to constitute a tribunal. I have seen the affidavit filed by the respondent number 5, Chief Officer Assam Rifles. He too agreed that the matter may be referred back to District Council, whereby District Council may constitute a tribunal, and all the parties may address their grievances, my lord. That is one of my prayers.
We have agreed. In fact, my lord, on several occasions, I have stated that the.
It's like, do this is their own.
Yes. Because the order was passed by the Deputy CM against the order passed by the same of Sora regarding the demarcation of boundaries of certain villages, 3 villages. Now, the same of Sora, besides deciding the issue of demarcation of boundaries, my lord, will come to page of the order of the same.
You want it to be remanded to the executive committee?
Yes, we also have no objection that it should not the executive committee, my lord. It should go to the tribunal.
No, that they will constitute one man. The tribunal is not a fixed person.
No, my lord, as per my instructions, now there are 5 tribunals.
No, but it's that's
I've
not a fixed person. Now, where's Mikanta? Now, when an order is passed, it has to constitute a fresh tribunal or the existing tribunal?
No, my lord, as of now, there are 5 tribunals.
Oh, you appeal with this council,
Yes.
sorry. Yeah.
There are 5 tribunals which have been constituted by the council and approved by the government also. 5.
5 persons are.
Yes.
Is a 5 member or?
No, 5 persons, 5 tribunals.
Separate tribunals?
Separate tribunals. Because there are a large number of cases.
Yes, headed by executive member.
Yes. Not executive members.
Judicial officer.
Judicial officers and the officers of the district council.
Okay.
My lord, Lordship may set aside the impeach order and let the District Council constitute the tribunal.
Well, let's
Impeach order, page number
setting aside
129.
the entire order, because, my lord, as I said, there are two
The
points.
one of village is not aggrieved. It doesn't matter.
Because the CM is not aggrieved. The CM has never come on to challenge this order, my lord. They have never challenged. My lord, we come to page 107.
Yes.
This is the last part of the order passed by the CM. But we will see the border or boundary of administration of Lightlandop village, which falls under the Raj Laikur Sankur, will start from Umping Bridge till Lausli till and towards the south also. That the tourist spots is located towards the west of Mausawa Falls, including the parking lot for the tourists constructed by Lindop Village, but they will have to obey the authority of Sora's aimship according to the existing customary laws. The border or boundary of administration of Lindop Village, which falls under Raj Sora Majai, will include only those areas with houses of villages. The Sardar of Lagdo does not have any authority to grant new plots for new construction of houses to the people or villages of Lagdo without permission from the CM and his Durbar. So, my lord, the same of Sara went one step ahead. He did not confine himself to the decision regarding the boundaries.
Is usurped jurisdiction.
Yes, and then that is why, my lord, at the last page, 187 of the impinge order.
But has the deputy CM gone in detail?
He has gone in detail, but my lord, I submit that, of course, he ought not to have gone into the details regarding the boundaries. Now, apart from fixing the boundaries of the three villages, my lord, the deputy CM also said that the CM of Sora has no authority over the land administration. My lord is also aware that as on date, the district council has enacted the Land Administration Act in respect of land administration. What the CM of Sora has done, took a step forward and said that, okay, I'm fixing the boundaries of the villages. However, the land administration
is with me.
Is with me. That
no, we do one thing. We let the tribunal revisit everything.
Yes, and the status quo be maintained.
Yes,
that is the impugn order, and the tribunal may address the issue.
We'll have to go. Yes, we'll have to go. But if we are to do it afresh and we're allowed to adduce,
yes,
allowed, we'll have to go. Right. Take down his.
Lordship, appearing for the respondent number 4, I filed my affidavit, Lordship, as submitted by my learned senior Lordship. I pay for that status quo to be maintained.
It's status quo to be maintained, naturally.
Status quo to be maintained, you also have for the small 5. Is the customary who is collecting data for the customary authority?
Will this come up from the tourist activities?
That is why that tourist sector.
A lot of disputes are coming up now.
No.
Because of
what has happened is that the CM wants to retain that power to collect these.
Who's appealing with CM Sora?
But let us see senior.
But they have never challenged the order of the district council also.
They should make your tourist policy now, since yes.
Collection is not the issue here.
Collection,
boundary disputes, man.
Yes.
Boundary dispute is the issue here. Collection, man, of what because some say like
no, that's just in jest. Because if you do that, it's get a lot of problems now. Yes. The writ petitioner. Who is the headman of writ petitioners who are headmen of
three villages,
namely Umblai village, next Mapu village, and Lightendop village, all of Sora's imship, are before this court, assailing the order dated 19/12/2023, passed by the Executive Committee, PHADC. Stop. The brief facts surrounding the case are that the brief facts surrounding the case is with regard to a boundary dispute raised by Laidu village is respondent number 4 against the village's petitioners, wherein the matter travelled before the respondent number, respondent number 5, who by order dated, where's that?
16.8, my lord, 2022.
16.8,
2022.
2020, that is page, sorry,
Page number 98, my lord.
93.
98 of the writ petition.
Former, travel to some, sir. Over order 16, apart from demarcating the boundaries, had also passed other orders touching upon land administration and respective and jurisdiction. Stop. Thereafter, the who filed before the
We filed the
thereafter the
particular
petitioners against the said order had approached the respondent number one, that means
Well,
respondent number, Mr. Counsel, respondent number
1, 2, 3, my lord.
respondents number 1, 2, and 3. Whereafter, by order dated December, order dated 19/12/2023, the impugned order had been passed. Stop. Next paragraph. In the course of the proceedings, and looking into the facts pertaining to the entire matter, it appears that as the matter concerns dispute between the 4 villages within Sora's Imship as to its boundaries, the parties have agreed that the matter would be best served if the same is taken up by the by a duly constituted tribunal under the Administration of Leca Act. Which year is that?
1991.
1991. Stop. Next paragraph. Accordingly, it is directed that the instant matter shall be referred to the Executive Committee's Council, who shall then place the matter before a duly constituted tribunal for adjudication. You want to file fresh representations or whatever required that they will do?
Well, liberty may be given to all the parties to, my lord, file a fresh petition.
Yes. Stop. It is further provided that once the matter has been referred and parties put to notice thereof, they shall be allowed to file fresh representations through petitions in support of respective cases. Stop. Any time frame, not necessary.
According to my instruction, my lord, within 2 months we can complete.
Yes.
Since status quo has to be maintained, that this order has to go dated 17 March 2020. Directing the CM to stop the implementation of the
17 is impugned here, 17/10/2022.
the affidavit of opposition.
No, it's not impugned.
Not
right?
impugned.
No.
Then we can't go there.
This may stand on to be.
No, they can pass in. They can pass interim orders. In that
Yes,
matter.
the tribunal
Yes,
can
so,
pass.
no? But what thereof, days the end, what they reference to petitions. Yes. Yes. Next paragraph. The entire exercise shall preferably be concluded within the period of 3 months from the date the matter is referred to the tribunal and the parties put to notice. Stop. Next paragraph. Needless to add, the impugned order shall stand set aside and quashed, and further the party is directed to maintain strict status quo during pendency of the proceedings. Yes.
Much of that.
Matter stands closed in this program.
Daily list item number 1.
Who's appearing for number 3?
So Mr. Paske was appearing for 3 and 4.
Paske is appearing for Mr. Respondent number 3 and 4.
Where's the affidavit?
Lordship,
You are appearing for number 3 today.
Respondent number 5. Number 3 and 4.
Then why Mr. Paske is not appearing? Where's he?
Lordship, I'll be filing my proclama for respondent number 5.
Number 5.
So, I'll be filing the possibility.
Paske 3 and 4. What's the matter about?
Cancellation of Patta, Lordship. Challenge to a cancellation of Patta.
Number 5 is whom?
Lordship, it appears there's no
Name? There's no number 5.
Lordship 3 and 4.
They've been deceased, Lordship. So,
They were substituted.
No, Nogan Marat, number 3. Have been implemented, and Mr. Paske is appearing for them.
I'll be filing my proclama.
For whom?
For respondent number 3.
Nogan Marat. So you said number 5.
I was mistaken.
You don't have the brief with you.
No, Your Lordship.
What is this? But Mr. Paske entered appearance. Look at the last order, 28-8.
We just received the number.
No, you're appearing together, Mr. Paske. Then you say that. For 4 also you're appearing, that means.
4 has also been struck off.
Your Lordship,
Struck off.
3 and 4 is struck off.
Yeah, 3 is then you be clear, Mr. Lasanga, yeah. Otherwise, yes, Mr. Lasanga, yeah. General Counsel, Vice Mr. Pierre Paske, praise funds allowed for the time to file affidavit. This thereafter. For 2 weeks. You be clear, you have to have. Look at the order sheet of the case before you submit.
Number 2. May I please, Your Lordship.
5 and 9, any affidavit? No. Be filing? Yes. Do you want to file affidavit? 5 and 9 is? 5 and 9 is the village.
Yes,
Let them file.
Yes. Will do, Your
Can
Lordship.
see, yes, Ms. Arkakan Council was appearing for respondents 5 and 9. Submits an affidavit be necessary to be filed. How much time do you require? He pays for 2 weeks to file affidavit. This thereafter. You have to wait on the question and intimacy. Yes.
Item number 3.
Please, Lordship. I'm
Yes.
paying for a further week's time to file my rejoinder, Lordship.
How many times have you prayed?
Lordship, the affidavit was filed on 3rd of September.
Third of?
September.
Okay, 2 weeks time must prayed. Allow for a joint affidavit. List that after on some.
Much obliged.
Item number 4.
Well, the appeal proceeding is not concluded, so your lordship may kindly take it up on 3rd of October. 23rd, the appeal is coming up for
3rd October, but then that's just before Puja holidays.
27th or 20. In that case,
3rd of October. Take it after that. What has happened to the appeal?
that is coming up for consideration on Monday, this Monday.
23rd of September, madam, it's coming.
But is it moving anywhere? It's just stuck in the same place.
Still stuck.
Or is that matter or regarding? Yes, okay, I remember. Yes. Right, Mr. S. Datta. There's a matter we listed after 2 weeks.
3rd of September.
3rd October, yes.
3rd of October.
Not objected to by me.
Take the correction.
5.
Yes, Dr. Mojika.
The instruction I have received, my lord, the file has been sent to ministry for consideration, my lord.
What's the matter about? Complying with which order?
It's pay parity matter, Assam Rifles.
Parity.
I'm praying for some more time, my lord.
How much time? When is this filed? 1/8, okay. 2 weeks further time.
But I'm praying for it long.
3 weeks time further time allowed to the NCIG to obtain necessary instruction. Just thereafter.
6.
Lordship, in this matter, there is a deliberate concealment of the material facts. And for which we have filed the misapplications. It has come for order today. Your Lordship will find that judgment and order in this case was passed on 24/4/2024.
Yes.
And against the direction contained in paragraph 12 of the judgment, we have filed the writ appeal on 13/5/2024.
Yeah.
And the writ appeal was listed for admission on 17/5/2024. Your Lordship will come to Annexure 1 of my petition.
Yes.
There is the order of the division bench.
Yes.
Appeal is admitted. During the course of argument, learned senior counsel appearing for the corporation submitted that the respondents have not been engaged in any sanction post on, and they are continuing their work duty for 3 hours per day till date. Learned senior counsel fairly submitted that these persons have been working for several years as part-time employees, and unless sanction posts exist, their services cannot be regularized. He further submitted that there is a disputed question of fact involved, and the same could not be agitated in the writ petition, and the order of the learned single judge in granting the relief is not correct.
Yes.
Then your Lordship, taking note of the submission made by the learned senior counsel that the existing persons will not be disturbed from the services till the disposal of the writ appeal, let notices be issued to the respondent returnable by 24/6.
Yes.
We have taken steps for issuance of notice. And
where's Mr. Jha?
My lord, the conducting counsel is out of station, so I would pray for a week's time that the matter may listen.
Lordship, we have this is a contempt proceeding, your Lordship, in which he has got nothing to do. This is a matter between the court.
Let him be here.
And your Lordship, that just putting a sword on overhead and concealing this fact, he appeared before the appellate court.
This contempt was filed when?
This contempt petition was filed on 27/8/2024.
And the order of the division bench is?
Yes, 17/5/2024. And he entered appearance on 21/8/2024. And he concealed this fact, your Lordship. And Power Secretary is...
I'm appealing for Power Secretary, madam. The respondent for one. Madam, there is no direction to the Power Secretary. The direction that has been issued, if at all, madam, that is for the compliance of the NIPCO. So, my lord, what I pray, my lord, at this stage.
We'll close it. Let Mr. Jha come.
Only the notice against Power Secretary will obtain appeal for time.
No. We'll close it. We'll have to pass some direction.
Your Lordship
doesn't matter. Appear doesn't appear. You can take it. You can.
Your Lordship may kindly record our submission.
Yes. Let Mr. Jha, poor fellow.
Monday.
Account Monday is. Miss case number. Miss case. Contempt case 5/2024. By this dismissal application, the respondent NIPCO has brought on record the fact that the order stated to have been violated has since been taken on appeal, whereby interim orders are operating, dated 17/5/2024, prior to the institution of the contempt application. Court takes serious note of this matter. Post this matter, this one matter stop. As the Parliamentary Council stated to be, it's not available. This matter on Monday. All that is.
Highly obliged.
Item number 7.
Please, Your Lordship, this matter is the last date. I'm supposed to bring the status report of the other respondent 8/9 to 11. Unfortunately, I've received the status. It says that it has been returned unserved. So,
Incorrect address.
It doesn't say anything. It just say return unserved.
No, it must be noting there. It can't just be returned. 8, 9, 10, 11.
Yes, 8 to 11.
That is, say, yes. Right? This is the first time I've heard of such a noting. What does inconvenience address mean?
The status that I received from the post office says return to sender. Doesn't
Return to
give
sender,
a reason.
yes.
Doesn't give a
given
reason.
Inconvenience address. What do you mean inconvenience address? What is the convenient address?
Inconvenience, maybe it might be located in a location according to my understanding. Difficult to serve, maybe.
Oh, same. Can you affect personal service?
But the only reason I've made them a party is because they are correspondent, they read petition, letters and correspondent, also addressed to these people. For that reason, I have seek for impleading, which I have impleaded.
Them?
Now, the other respondent, 567, differ.
Please, Your Lordship, I'm entering appearance for respondent number 5, 6, and 7.
Very good. What do you do? 8, 9, 10, 11? Strike them off. Are they necessary parties or just proper parties?
Just proper.
Can the matter be disposed of, put down? They don't have any material things to say.
Nothing as such. As per the letter, it's just that it's addressed to them. I've made them a party.
But can you affect personal notice? No. Difficult. Inconvenient address.
No, I have not filed any affidavit.
What affidavit are you talking about?
That's my affidavit.
This hasn't come. These letters, I mean, these petitions are here, they've been returned.
Yes.
Are you appearing for 8, 9, 10, 11?
No, he is appearing for 4.
Then, yes, notice on respondents number 8, 9, 10, 11 have been returned unserved with the noting inconvenient address. If MS Marpan submits that the respondents 8, 9, 10, 11 were impleaded due to the fact that their names appear in some correspondence, but otherwise they are not necessary.
Exactly.
From that view, the matter 8, 9, 10 11 is then struck off, and the matter that be proceeded with his and conduct by MS Arkas hearing today entered appearance on behalf of 5, 6, and 7. You want to file affidavit?
I have just received the.
No, you file affidavit or not?
Well, the state
And
also
please-
will file affidavit.
And please, Lord, 3 weeks time to file affidavit. Similar prayer made by MS Arkon. What about you? You file affidavit? Yes, list of the 3 weeks. Registry to strike off the newly implemented respondent 9, 10, 11.
Item number 8.
Yes.
Not here, as far as the government is concerned, my lord, we are awaiting instructions. My lord.
When was matter filed?
This is regarding appointment, my lord.
This is an appointment with regard to, we have challenged the appointment of a private respondent, my lord.
What about number 4?
Number 4, my lord, I'm informed that the service is already complete, my lord.
Are you filing affidavit? No. When will you file? You're for number 5. Mr. Estapa submits that the to his knowledge, to his information, respondent 4 has been served. April firms allowed 2 weeks time to obtain status report. Yes, next paragraph. Mr. Kivar Chaji and Mr. S.E. Mazari for state respondents and Mr. S.E. Sheikh for respondent 5. Pray for allowed 2 weeks for a time to file affidavits. Just up to 2 weeks. Yes.
9.
Lordship, we have received affidavit from the respondent number 3. And so,
who's number 3?
Lordship, I am appearing for respondent number 1 and my affidavit in opposition is ready, my lord.
You file it today?
Yes, my lord. I'm going to file it today.
Yes, Mr. Pidas for R1 submit an affidavit on behalf of the said respondent file in the course of the day. So then your name?
Z.A. Chaudhary. Z.A. Chaudhary.
Yeah.
We'll be filing our rejoinder in 3 weeks, Your Lordship.
Z.A. Chaudhary submits that, praise that, you mean how much time to file to number 3? You file yours?
No, I'm not filing. Respondent to HDFC. Respondent
Number 2. Yeah?
Number of the petition.
You already filed? Yes,
We have not.
Mr.
I
Z.A.
just
Chaudhary
need to-
prays that you have 2 weeks time to file rejoinder to the affidavit filed upon number 3. Mr. Next file, S. Marapan is allowed how much further bonus for them?
2 weeks.
2 weeks for him to file affidavits after 2 weeks, yes.
Obliged, Lordship.
Item 10.
Wait, please, Your Lordship. Your Lordship, here the money has, a sanction order has been issued for release of the.
My lord, today we got the money. We have received the money today, my lord.
Will withdraw, you didn't withdraw it. Mr.
P. Ghosh. P. Ghosh, my lord.
Mr. P. Ghosh submits that the matter has since been delayed and fluctuates as the amounts have since been received by the petitioner. Accordingly, matter stands for unbeing fluctuates.
Obliged, Your Lordship.
Blessed.
11.
Yeah, please, Your Lordship. Your Lordship, I'm praying for some time, Your Lordship, to file my affidavit for the
In the
state, Your
course of the
Lordship.
day.
Not in the course of the day, Your Lordship, for some time, Your Lordship.
2 weeks further time as per only state respondents, no other private respondents.
No, Your Lordship.
As per allowed for affidavit. This thereafter and so on.
Highly obliged, Lordship.
12.
Please, Lordship. Lordship, I'm appearing for respondent 1, 2, and 3. I have not received any instruction, Lordship. I pray for some more time. The interim order may continue, my lord. Next date. There are 2 private respondents. We have already taken steps on the private. Yes, ma'am. My lord, we have taken steps, my lord.
Not received. Office note indicates that the respondents indicates that the service report on respondent 4 and 5 is still not complete. A service not complete. Yes, from Mr. H. Karmi, 1 to 3 page response out further.
2 weeks time.
To obtain affidavit. Just after 2 weeks for service report on respondents 4 and 5 and for affidavit by the state respondent stop. Interim orders shall continue till the next date.
Obliged. 15.
Accordingly, and so on.
May it please your lordship. Lordship, here we're supposed to file affidavit, your lordship. I humbly pray your lordship, if your lordship can grant us 3 weeks time, lordship.
3 weeks for that time is prayed. It's allowed for affidavit.
Which one, lordship?
14,
Should we have taken steps on the private respondent?
Respondent, may it please your lordship. Lordship, I'm appearing on behalf of respondent number 1 to 5, your lordship. Lordship, I pray for the 3 weeks time as well, your lordship, to file affidavit.
What about other private respondents?
We have taken steps, lordship.
Number 6.
On number 6.
Number 1, whom? What's the matter about?
So this is regarding the extension of the check gate for trading of non-tribal licenses, lordship. They have extended for 2 years without any tender.
Yes, Mr. There is 6 only.
Lordship.
Only one private respondent.
Only one private. He is the one who is running the gate, lordship.
Yes. Office note shows that service on respondent 6 is not complete stop. Members of the group prays for, on behalf of other respondents, prays for further 2 weeks time for affidavit. Prays allowed list after 2 weeks for affidavits and for period and for service report on respondent number 6.
Much obliged.
hearing, supplementary list, item number 1.
Yes,
This is a case which become infructuous because of the resignation.
In the case of the respondent is that the matter has become infructuous, my lord, but my understanding is this, my lord, the cause of action still survive. Yeah, my lord, at least to
see, only one thing that the court not engage academic exercise.
No, it's not academic, my lord. My lord, may kindly come to my prayer, my lord, first.
Yes.
My prayer, my lord. Page 34, my lord.
Sorry. Page 34.
34, my lord.
Now, it quashed as an imputation process, okay?
Yes.
A.
As per the advertisement, my lord, we have also challenged the selection committee, my lord, constituting of the selecting committee, my lord. Because according to us, my lord, one of the member of the committee was representing the ST, my lord, whereas she was a non-tribal, my lord. By virtue of getting married, my lord, she has changed her title. But by changing of title, my lord, doesn't give her the right, my lord, to be a part of it. It's like you are honoring your husband and you just added a title, my lord. That is our case, my lord.
Now, my lord, no, but now one thing, Mr. Day.
My lord.
Now this selection committee is redundant.
No, they have not come clean on that, my lord. They should make a statement on that. The selection process has become redundant. They have not stated, my lord. Now let there be a fresh advertisement. Let them
this selection committee was constituted for one post of many posts.
No, there was many posts in other departments. I'm concerned only with my department, my lord. Now, if they are saying that the selection process has become redundant and there is no merit list, my lord, or a waiting list, I have no case, my lord. But if they are saying that there is a merit list or there is a waiting list, my lord, then I still, the cause of action survive, my lord. That is my case.
Okay.
If they are saying that they are going to do the fresh advertisement, my lord, I have no case.
Will it be a fresh advertisement?
No, but Lordship will see what happened when service matter. One post is advertised, selection committee constituted, recommendation made. Moment the person is appointed, there is no question of waiting list. That decision I have placed. Moment that person is with the selection is over, waiting list, everything goes. Now on his resignation, my lord, what happened? A fresh vacancy come into existence. Now once a fresh vacancy is come into existence, my lord, now there has to be fresh advertisement. When they will do, how they will do, my lord, that is the prerogative of the university, my lord. Nothing survives. If your lordship want to see, my lord, I have placed 2 decisions. One on, my lord, academic interest, who should not go.
what has fallen from my learned senior, my lord. Let it be recorded, my lord. Let it be recorded.
This is by operation of law, my lord. Once a person appointed, my lord, anti-selection rule.
There is no harm on recording this, my lord, submission of my learned senior, my lord. We learn from my learned senior in a service matter, my lord.
Will be recorded, yes.
Yes, my lord.
No, regarding my lord, when they will be
Down, yes. The writ petitioner, by the preliminary petition, had come for his court with the following prayers. We'll record all your prayers.
My lord.
What is the prayer? In the course of the proceedings, next paragraph, the respondent number 6, whose selection had been challenged, however, has resigned. Has resigned, and the post has been rendered vacant. So, next paragraph, Ms. SD submits that apart from the challenge made to the selection, serious reservation had been raised with regard to one of the members who stated to represent the scheduled tribe community.
These I have sufficiently answered in my affidavit.
Yes. Yeah. So,
My lord, senior is not appearing for the person.
that's the contention only.
No, I haven't. We have inducted her.
Let's just stop. He, however, submits that if the said selection committee is no longer, we don't say that also, but submits that if the post is to be freshly advertised, then these considerations. No, I thought. Representing the scheduled tribe, chair or scheduled tribe what member?
Yes.
Yes. Stop. Next, but to these submissions, not what was it? Mr. SN appearing for the respondent here, submitted that with the resignation of the selected candidate, nothing remains for consideration, inasmuch as by operation of law itself, the post has been rendered vacant and will be a fresh, and has been rendered vacant and will be accordingly be a fresh vacancy, which will be advertised in due course by the university. Stop. Whoever submits. What other submission you made? Nothing else, huh?
My lord, I have made a submission. He is saying that the selection committee induction of this thing. I have justified it, my lord. How she has been.
Submits that the manner of selection, the manner of constitutional selection committee. What do you say? Yes, will be. It's another.
My lord, as per the requirement.
Will not create anything. I thought. Respondency. Candidate. Yeah. Advertise in due course. If he also submits that there is no need, there's no occasion for this court to embark onto an academic exercise in this regard with regard to constitutional selection committee. Like in view of submissions and the situation it pertains on today, it is correct that nothing remains for consideration and the matters are only closed.
The only thing, if I can make clear, Lordship has recorded that my petitioner has raised serious questions regarding the constitution of.
So he said academic.
My submission is also. At least my submission is also. We have, my lord, justified, my lord, that the constitution only record that, Lordship.
No, please return this.
Because as per our affidavit, my lord, we say we have.
I'm just recording his contention. That's all.
Only my answer only, my lord.
They should in the advertisement, my lord, they should follow the UGC norms.
We have followed, my lord. Yes. We have followed everything thoroughly, meticulously, my lord.
And that is why he resigned, my lord.
In fact, my lord,
that is why they resigned, my lord.
This is an absolutely frivolous petition, my lord.
That we would have proved, my
If we
lord.
have got the opportunity, my lord, this is to be dismissed with cause.
19.
Yes. 19. 19 year there, Mr. Day.
Wait, please, Lordship. Lordship, this is a challenge to the termination of the petitioner from the post of manager of Meghalaya Rural Bank.
Yes.
Lordship, my grievance as far as this petition, Lordship, the allegation was an issue of misappropriation. For that, a criminal case, misappropriation, Lordship, by the cashier of the bank, apparently in connivance with the petitioner here, who was the manager. Lordship, as far as that aspect is concerned, the case is pending in the court of Joy under the relevant provisions of the criminal law, Lordship. Here, Lordship, we are aggrieved with the inquiry, disciplinary inquiry proceedings on primarily two grounds, Lordship. That inquiry report was never given to me, Lordship, and I had no opportunity to represent against the findings of the inquiry report, which has culminated into the dismissal order, Lordship.
Is that correct?
And
Yes, Your Lordship.
You have never communicated it.
No, the inquiry report was not furnished to him, Your Lordship, but then they have not been prejudiced in any way by non-furnishing
we'll
of
hear
the
that,
inquiry
yes.
report.
Yes.
They've neither pleaded prejudice nor have they proved prejudice. And he participated. Anyway, let him finish, Your Lordship.
Yes. No, if that's the only ground, yes.
that is the main ground, Lordship. Lordship will kindly come to page 69.
69.
69, this is the speaking order, Lordship, the final order. Starts at page 68, Lordship, annexure 19.
Speaking order.
Lordship, page 68 is just the forwarding. Kindly
Yes.
see page 69, speaking order of 30th June 2022. I have carefully, independently, and dispassionately studied the following documents, so and so, Lordship. Now, kindly see the documents. It's been mentioned.
Where? Page 68 says private and confidential. We forward a copy.
Page
What is this
69, Lordship, is titled as a speaking order.
Forwarding letter, Your Lordship.
69, Lordship.
Yes.
69.
Yes.
Lordship, I have carefully, independently, and dispassionately studied the following documents, papers placed before me in connection with the disciplinary proceeding initiated against Sri So-and-so, Officer Scale 1 under suspension for alleged serious irregularities and gross misconduct committed by him while he was posted as a branch manager at Meghalaya Rural Bank, Khanduli branch from so-and-so to so-and-so. Lordship, it has been numbered as directly from 7, ought to have been from 1. Lordship, the one investigation report dated 22nd September 2021, never given to me, Lordship. Till today, I am not aware what is that report. And the one at the end, Lordship, of this list, departmental inquiry report dated 21st June 2022, also, Lordship, admittedly never given to me, Lordship. Thereafter, Lordship will kindly see the finding at para 3 of this order.
Yes.
The inquiry authority conducted his inquiry into the charges at the bank's head office, Shillong, and submitted his report on 21st June 2022, while the petitioner, the charge-sheeted officer, had in the course of inquiry denied the charges level against him. Accordingly, the inquiry has in his inquiry report found 5 out of 5 charges as proved. And thereafter, Lordship will kindly see, it is evident that this is on the merit, Lordship. Kindly see para 5, the finding. Having therefore considered the gravity of the lapses committed by Shri So-and-so, I, in my capacity as the competent authority, order that as per regulation so-and-so of Meghalaya Rural Bank Officers and Employees Service Regulation 2010, Shri Ricardo Richmond Lalu, Officer Scale 1, be dismissed from the bank service with effect from the date of his order. Further, the pension benefits applicable to Shri So-and-so will be as per regulation 29 of the rules, subject to the approval of the board. Moreover, the period on suspension of Shri So-and-so shall be treated as having been not on duty. However, substantive allowance may not be required. Also, this order was passed without the supply of the investigation report as also the inquiry report.
How do you say that? Is it I've carefully independent one documents? This one correct?
No, I have never given it. That is an admitted, Lordship. Now, thereafter, Lordship, this order was passed by the chairman and being the competent authority. Dismissal. Now, I have filed an appeal, Lordship, raising these grounds that I have not raised.
Yes.
I have not been given the
documents.
Yes, documents. Lordship, kindly see my appeal at page 74.
Yes.
just to sum up the contention, Lordship, of page 74, Lordship, the paragraph begins with whereas, Lordships have it. Lordship, bullet point 1, copy of the said brief of present officer was not provided to CSO. Since the brief was not provided to me, I was deprived of legitimate right of submission of defense. Did not submit a defense brief, lost an opportunity. Copy of the findings of the inquiry officer was not provided to me. Apart from the disciplinary authority committed a grave mistake by proposing penalty without giving second show cause and opportunity to submit the reply to the findings of the inquiry officer. In the speaking order dated so and so served on me, it stated the disciplinary inquiry authority had that the inquiry authority had conducted inquiry and submitted his report on so and so. This clearly shows the inquiry had submitted his report, which was not provided to CSO. So I have raised the ground, Lordship, that this was not given to me. Now, thereafter, Lordship, on appeal, kindly see the on the statutory appeal, page 76. Page 76.
Yes.
Lordship, this is an order of 26th August after I filed my statutory appeal as per the rules. We have put up your captioned appeal dated so and so to the board of directors in this 240th meeting held on so and so. Board perused and noted that you are not furnished with a copy of the presenting officer's brief, owing to which you could not submit your defense brief. In view of the above, the board has come to a unanimous decision that the copy of the presented officer's brief will be furnished to you and you will have to submit your defense brief after receiving it. Thereafter, the board will be reviewing your appeal after your defense brief has been submitted. So one of the two issues, Lordship, inquiry report was still not submitted. Presenting officer's brief was submitted to me. Lordship, thereafter, I have kindly see what actually was submitted to me at page 77. Page 77, Lordship, is the presenting officer's brief, having the findings of the presenting officer, Lordship. But again, here also there is no indication of the findings of the inquiry officer. And separately, inquiry officer report of 21st June was never supplied to me, Lordship. Lordship, thereafter, as on the basis of this presenting officer's findings which were submitted to me, I have filed my defense brief, Lordship.
Yes.
Lordship will have that at page 82. I have filed my defense brief that was duly received. Thereafter, Lordship, at page 89, the second impugned order on appeal.
89.
Page 89, Lordship.
Yes.
Lordship, impugned order of 18 January 2023. Again, Lordship, I have carefully, independently and dispassionately studied the following documents paper placed before me, so and so, so and so, so and so, and his subsequent appeal dated so and so to the board of directors. So it appears, Lordship, that the language is more or less the same. Chairman has studied it along with the appeal. That is one part, Lordship. I will just come to that. Now here again, Lordship, the one at point number 1, investigation report of 22nd September 2021 was never supplied to me, Lordship. And the one at point number 6, Lordship, departmental inquiry report dated 21st June 2022 was never supplied to me. Lordship, again, the similar finding has been reiterated at point number 3 of the appellate order, that inquiry report was submitted and found all the charges as proved. And thereafter, Lordship, kindly have page 90. Paragraph 4 is the same repetition of the earlier order. Kindly see paragraph 5, which they have added. The appeal of Sri Ricardo Richmond Lalu dated so and so was put to the board of directors as meeting held on so and so, and the board noted that he was not furnished with a copy of the presenting officer's brief, owing to which he could not submit his defense brief. After due deliberation, the board of directors in its board meeting held on 18 January 2023 had decided to uphold the decision of the competent authority to dismiss Shri so and so from service. Having therefore considered the gravity of the lapses committed by Shri so and so, I, in my capacity as competent authority, ordered that, as per regulation so and so, Shri Ricardo Richmond Lalu be dismissed from the bank service with effect from the date of the order, and pension will be subject to the approval of the board, Lordship. This order also, although they have stated that it was placed before the board of directors on 18 January, order still was passed by the chairman, Lordship, who was the same person who passed the initial order. And Lordship, what was what happened on the alleged meeting of 18 January 2023, we don't know, Lordship, whether the board of directors in fact passed any speaking order. Lordship, thereafter, I have also annexed my charge sheet at page 91, which is regarding the case of which is going on, just to show on the merit aspect, Lordship, that what exactly was the allegation. Lordship, may be pleased to come to page 99. Page 99 is part of the deposition under 164 by one Mr. Reginald Shilla. He is the, he's Lordship, the regional manager of Meghalaya Rural Bank. Let me just to show a background, Lordship. I am aware of the case. On 19 September 2021, I visited Meghalaya Rural Bank's Khanduli branch as I could not visit the same due to COVID-19 pandemic. I reached at Khanduli at around so AM. I reached the bank before 10 AM as I had to check the cash amount available in the bank as I was the controller. When I reached Meghalaya Rural Bank Khanduli branch, the cashier Almiki Shilla was already there and I told him that I want to check the cash, but he tried to delay and told me that there was no electricity downstairs at the branch office and it was dark. So I told him to take out the cash outside so that I can check the cash. The moment I said that, the cashier Almiki Shilla confessed that he had misappropriated a sum of rupees 10 lakhs. And there I asked him from which time there was a shortage of cash, and he told me that it was since the month of February 2021. At that time, the branch manager of Meghalaya Rural Bank Khanduli branch, namely Richmond Ricardo Lalu, the petitioner, was also present. I asked him why there is a shortage of cash, but he told me that he was not aware about the shortage of cash. There I asked him how he is not aware when there was shortage of cash from the month of February 21, as it is the duty of the branch manager to check and verify the cash every day in the bank. The cashier Almiki Shira prayed that to pay the cash amount which he had misappropriated, and I gave him 48 hours time to repay the same. But till date, he has not repaid the same. He's asking for more time to repay the same. Therefore, thereafter, after learning of the misappropriation of cash, we deputed one branch manager, Shri so-and-so at Khanduli branch, and later he lodged an FIR. So this was the background allegation, Lordship, that the cashier had apparently misappropriated. I was the branch manager. So that case is still pending, Lordship. But at this stage, my humble submissions are, Lordship, the judgments of the Honorable Supreme Court in the case of Manager ECIL and B. Karunakar and various other judgments, Lordship, as well as certain other judgments passed by the Honorable High Courts as well. Lordship, the inquiry report on the basis of which the impugned order has been passed has never been supplied to me, and that, Lordship, has caused immense prejudice to me because I don't know how the inquiry officer has come to the conclusion, Lordship. And I also say that, Lordship, because if Lordship is pleased to come to page 50, 50.
1 second.
Lordship, please.
Page 50.
Page 50, Lordship. Lordship, this is the part of the charge sheet which was drawn up against me. List of documents and witnesses on the basis of which the allegations framed against Shri so-and-so while he was posted so-and-so. List of documents, Lordship, branch register pertaining to cash, receipts, rolls, and other areas of branch operations. RO letter dated so-and-so regarding reporting the alleged fraud by the regional manager. And list of witness, Lordship, regional Lingdo. Lordship, there is no indication in the impugned orders also that these documents or the person concerned was ever examined. In fact,
Yes,
it was not examined.
what is What is this?
In this case, Your Lordship, the petitioner here was a branch manager of Khanduli branch.
Why was he not prejudiced, do you say?
Your Lordship,
Supply of his
because
document.
he has himself admitted that, the fact that there was a misappropriation of the money in the branch, of which he was a joint custodian, Your Lordship, has been admitted, Your Lordship.
Fine, but what is culpability to the extent where this punishment can be less upon dismissal?
No, because Your Lordship, even if he was very much aware that he has to sign the register, the bank balance register every day, Your Lordship, and he has been signing that. But Your Lordship, the physical amount in the vault was 10 lakhs less than what was in the bank register, of which he was aware, Your Lordship. But then when there was an inspection in the branch, which is
How do you say he was aware?
he has signed the branch register, Your Lordship, the balance register.
The
and
branch manager to physically verify the cash amount.
they have to, Your Lordship.
Every
That
day.
is the rule, Your Lordship. That is rule.
So bank has
Wait a minute, he is a joint custodian because he holds the key. One key is held by him and the other key is held by the cashier, Your Lordship. So he is supposed to know what is in the vault, Your Lordship. How much money is in the vault, how
He has
much,
to count it physically every day.
it has to be, Your Lordship. Otherwise,
Means State Bank now branch managers around 150 crores he has
Your Lordship,
counted.
they do that, Your Lordship, because that is the rule, Your Lordship. But even if you don't do it every day, Your Lordship, it has to be done regularly, on a regular basis, Your Lordship. Otherwise, there's going to be bound to be chaos in the branch, in the banks, Your Lordship. Money is going to be misappropriated. The branch manager won't know what is happening in the vault, in the cash department, Your Lordship. So, Your Lordship, when he is holding the key of the vault, along with the cashier, he is supposed to know.
Fact of the case aside, now in the conduct of proceedings, did you give him adequate opportunity? His case, simply put, is that in the course of proceedings, he was not given adequate opportunity for himself, and he was put at disadvantage because certain these very important documents, were not given to him.
No, Your Lordship,
And so that has totally, handicapped him in the sense that he was not given a fair inquiry. That's all. And prima facie, if that is correct, and you don't deny that inquiry report, you set aside both these orders, and then you have a fresh inquiry.
We can do that, Your Lordship. after
Reinstate him to
furnishing-
service, or we just let him be paid substance allowance
He may be
again.
reinstated and kept in suspension as per the judgment of ECIL.
Your Lordship, the fact of the matter is that, Your Lordship,
Can go back from
I have, Your Lordship, may kindly peruse my
Affidavit.
affidavit also, where we
How
have.
you have to improve your case, but even then, if
No,
you
but
really have
one-
nothing to the contrary to show that,
That I
that
have
matter
admitted,
justice
I have,
come in to that extent. There are cases where null justice does not come in also, depending on the fact and circumstance of the case. But it has to be such a case. Yes, let's see affidavit.
this affidavit of the respondent number 1, Your Lordship. Here we have, you may come to para 11, Your Lordship. That the answering respondent denies the averments made in para 3 of the return, states that when the regional manager 1, that Reginald Shilla, visited, inspected Khanduli branch on 9/9/21, he found that a sum of 10 lakhs was missing from the cash vault. While the branch cash balance register on this particular day showed 18,35,769 only. The physical cash in the vault was only 8,35,769. The regional manager who inspected the branch has stated that an inquiry from both the branch manager, who is also the petitioner in the instant writ petition, and the office assistant about the discrepancy detected, the office assistant admitted that he had misappropriated the cash from the vault without the branch manager's, and that he promised to make good the shortage. Answering respondent, however, states that it cannot be accepted by any stretch of imagination that the petitioner is innocent by the mere statement that he had no knowledge of the same, as claimed by him, as he being the branch manager and the joint custodian of the vault key, was overall in charge and had the prime responsibility for the safety and safekeeping of the money which belongs to the public, and as per practice in all branches.
Right. No, that indiscretion or whatever violation, whatever that has been committed by them, fine. But only that from
So,
your
Your
part,
Lordship,
regarding the procedure adopted.
the procedure is
whether-
also, Your Lordship, I
do you
think-
have any other materials to show
There is
that,
the minute
that he was
also
given
is there,
adequate
Your Lordship.
opportunity that the documents supplied to him
Documents, he was allowed to peruse the documents. He wanted to see the documents.
What, did he have a defense assistant? Was he offered one?
Yes, he had a defense assistant. He was allowed to peruse the documents, Your Lordship, and he participated in the proceedings, Your Lordship.
But was he given
And
the
after
inquiry report?
participating, Your Lordship, of course he pleaded not guilty, but then when the proceedings were over, if he was also, and he has signed the minutes also, Your
Why is not
Lordship.
given a copy of the inquiry report?
That, Your Lordship, was oversight by the inquiry officer, Your Lordship. So we have conceded to that the inquiry report was never furnished to him. But from the overall scenario, Your Lordship will see that, Your Lordship, no prejudice has been caused to him, Your Lordship. He was responsible for the bank money. He has acted in a very negligent and a careless manner.
That we cannot, even there might be anything, but then due process. That's
Yes, due process is there, Your Lordship. He has, in fact, also signed the minutes of the thing that I am satisfied with the inquiry. The defense assistant was there. He has not raised any objection. Even the dismissed officer, the petitioner here, Your Lordship, he has signed saying that are you satisfied that equal and adequate opportunity has been given to you?
Have you answered an affidavit as regard to the non-supply of inquiry
Yes,
report? Where is
inquiry
that? Where have you replied?
It is here, Your Lordship, that we have stated that it was not given, but no prejudice has been caused to him. That is what we have stated here.
Kindly see para 24.
Para?
24, Lordship.
Of the affidavit.
Of the affidavit.
Do you have any authorities, similar cases where inquiry report has non-supplied
Yes, Your
inquiry report
Lordship. Yes.
has not vitiated the proceedings?
Yes, it does not vitiate the
Have you
disciplinary
do
proceedings.
you have any authorities?
I have it, Your Lordship.
Kindly see.
That even ECIL, which my friend is thing, it says very clearly, they have to prove prejudice, Your Lordship. Mere saying that inquiry report was not furnished is not
Why am saying prejudice have been caused? Because if he says not guilty, if the office boy said that, whatever.
That he was,
yes. Now, what circumstances were there? That's the thing. Inquiry says what? Inquiry report.
And Your Lordship,
No.
and Your Lordship, I have got citations which, if Your Lordship.
Where's the inquiry report in this petition? Where is it?
The inquiry report we have.
Can you show it?
I have it with me here, Lordship. We have not furnished. I think we have not
Why didn't you?
enclosed
Why
it
didn't you put an
here.
affidavit? That's also. That means the materials there that he could
Your
have.
Lordship, we can submit
second
it. There
show
is
cause.
nothing, of course,
Yes.
Your Lordship can
We'll go back to
presume.
the stage of 30. We will not reinstate him, but you pay him. He'll be suspended from 3622. You pay him his back substance allowance and recommence the proceedings
Lordship,
after providing a copy of inquiry.
Lordship, I would like to make a proper full hearing, Your Lordship, and submit my citations. Then Your Lordship,
Sometimes this court seems very terse and brief, but if the draft
no,
act
because
has that-
in this case, Your Lordship,
you show authorities. Yes.
I can show
I'm
you
not,
the-
I'm not shutting you down. Just show the authorities.
No, I can
that,
show you
that
the-
can support your
Yes,
submission.
I can
the
show you that.
non-supply inquiry report in these circumstances
does not vitiate the
has not-
disciplinary proceeding, provided,
has not caused prejudice to him.
yes, provided has
Causing
not,
prejudice, that means has not vitiated the inquiry
then yes,
proceedings.
it is there, Your Lordship. But if Your Lordship would give me 1 week's time, Your Lordship, I have
Why?
got it. In fact, I've given the list also, but
But then remember that that's the thing. Yes, we'll have for 1 week, no problem. But you understand
the mind of the court, Your
Yes.
Lordship, I've understood.
justice not to be done, seen to be done. Also.
Seen to be done. No, I.
Case of further hearing after 1 week. Yes. Parties to come up with authorities in support of their respective cases.
Item 30.
Yes, Mr. Chaudhary.
May I please your worship? Can I proceed?
Yes.
Can I proceed?
Oblige, Your Lordship.
The case is called out. You don't need permission of court to proceed. Yes.
Your Lordship, in this matter, the petitioner has got married actually after the death of his first wife. Petitioner has got married after the death of his first wife, the second wife.
So, first wife death certificate is there, Your Honor, page number 3. She expired on 19/7/2010, leaving behind the children and all are major, Your Lordship. So thereafter, Your Lordship, the petitioner, death of his first wife, he got married with one Surubala Burman, and out of that marriage, they begot two number of children. The first one is Providential Kharmukai, 12 years, and second one is Redolent Kharmukai, Your Lordship. So, copy of that certificate is also enclosed, my lord. Marriage certificate as well as their birth certificate is enclosed, my lord. So, here is simple thing, Your Lordship. The petitioner has written to the department concerned here, Your Lordship, to the senior accounts officer for changing the name of his second wife in place of his first wife's name. The representation was made on 13/10/2023, explained the details and requested to include the name of his second wife and the children in the pension payment order number MG 424, Your Lordship. This is paragraph 5 of my petition, my lord. So thereafter, Your Lordship, the department did not heed to that, and nothing was done, and no reply also given. So, Your Lordship, as per the pension rule, my lord, this is petitioner submits that marriage very entitled to get the family pension as per existing amended pension rule of Government of Meghalaya, Your Lordship. That is Rule 48(1)(a)(1). Provides for widow, widower is in the first category, and in the note 2, it is given of the Rule 48(1), provides for post-retirement spouses, children born after retirement, and therefore the petitioner's wife and children are very much entitled to go on record in the pension payment order as part of family members, Your Lordship. So my humble submission is that, Your Lordship, as per the amendment order of the Finance Department, it is very much covered, my lord. And in that context, my humble submission is that the second wife's name as well as the children's name is to be included in the pension payment. And moreover, Your Lordship, I want to submit one case law. Very recently, Your Lordship, it is decided by this Honorable Court 2/5/2024. This is Jamshedali versus State of Meghalaya, my lord. And this is a very covered case, my lord, regarding this pension. And
you were the petitioner.
Yes, Swarna was the petitioner in that case.
What case is that?
Yeah.
It's from this court only.
That is, yes, Lord, it's similar to this case only. My learned friend is referring that.
He's very smart. He's got all the right. Because the other decisions of this court only.
Yes, yes. And in that case, that referred earlier decision.
Supreme Court's decision also enclosed here.
Yes.
Referred it is.
In that case, Lordship, that the husband filed application for inclusion of his name, wife's name in the pension payment order.
This one, you married after the amendment?
Yes.
In this case?
Yes.
2010.
2010.
Got married.
After the amendment?
Yes, yes.
After amendment.
After amendment.
But even then it is
And
covered.
that is the stand taken by the government, Lordship. That's
what I'm reading, yes.
Yes, as per the applicability of the rule. Because the rule was made effective from 1st January 2007.
Yeah.
And he got married 2010.
Yes, take down. The writ petitioner is before this court praying for the inclusion of the name of his second wife, right?
Yes, sir.
And children in the pension payment order. Of the writ petitioner. So, the brief facts are that when they retire, that the brief facts are that the petitioner
VRS in 2004, Lord.
2004.
has retired in the year 2007.
Taken VRS, Lord.
No, 2004, yes.
1/9/2004.
1/7 or
1/9/2004.
1/9?
Yes, yes.
Yes, 1 in in 1/9/2004, and after the demise of his first wife, had remarried once Srimati Surala Burman, Surula Burman, on 4/11/2010. The grievance is that the respondents have made representation. Where is that? Where they rejected it. The respondents, in spite of
That is page 17.
in spite of where's that? In spite of his application.
Page 17, Your Lordship.
Page 17.
Yes, 13th October dated.
Yes, in spite of his application for deletion of the late first wife and for inclusion of the names of his second wife and children, have rejected the same. Next parameter, and Chowdhury submits that by operation of law itself and by the amendment to by option of law, that is the amendment to the Meghalaya Civil Services, within bracket pension, then bracket again 5th Amendment Rules 2010, post-retirement spouses, stroke children born after retirement is admissible. He therefore submits that the council further place the decision of this court rendered on 2/5/2024 in WPC 161/2023, which covers the case of the petitioner also. He therefore prays that manors be issued to the respondent as per his prayer petition. Yes, next paragraph. Mr. S.A. Sheikh, appearing for the respondents number
1 and 2.
1 and 2, has fairly submitted that the facts of the case are similar to the facts of WPC 161/2023, and in view of the decisions of this court and also the Honorable Supreme Court, the petitioner will naturally be entitled to the benefits as prayed in the petition. Any submission to make? No. Yes, MSEB Pasa, the counsel for the respondent number 3. Submits that whatever orders are passed will be implemented. Whatever passed, but it's not going to be implemented as far as the respondent number 3 is concerned. So, next para, having heard the counsel for the parties and as the aforestated facts are in dispute, the case of the petitioner stands covered by the judgment rendered in WC number 161 of 2023. Without elaborating on the same, it's directed that the respondents shall include the name of my appropriate of so and so, for the prayer number of prayer number 4. I think this names in the pension payment order. The matter of concerns closed in disposal.
Right.